This is State of Kansas X-Rail Kansas Highway Patrol Appellant V1 2011 Chevrolet Camaro. VIN 2G1FJ3D Appellee from Dickinson County, case number 129250. Would counsel for the appellant please state your appearance?
Thank you, Your Honors. My name is Stacy Bond. I appear on behalf of the state of Kansas, Kansas Highway Patrol in this matter.
Thank you. And for the appellee?
Good afternoon. May it please the court, counsel, members of the panel. My name is Barry Clark. I'm with Clark, Platt and Hopper from Manhattan. I represent Raul Garcia.
Thank you. Would the appellant like to reserve any time for rebuttal?
Yes, Your Honor. 3 minutes, please.
3 minutes are granted. Give us just a second to reset the clock. You may begin.
All right. Thank you. Your Honors, we're here today on a civil asset forfeiture matter in which the driver of a 2011 Chevrolet Corvette was clocked by a Kansas Highway Trooper on I-70 early morning hours in, I believe it was September of 2023. Initially, the trooper clocked the driver driving approximately 113 miles an hour in a 75-mile-an-hour zone. When the trooper then turned around to initiate the traffic stop, the vehicle initially pulled over to the side of the road. However, the driver never placed the car in park. The trooper had used his PA system to ask the driver to take the keys out of the car and put them on the hood of the car, because the driver's actions and activities were somewhat unusual for a driver that is going to actually comply with the requests of law enforcement. As the trooper was preparing then to exit his vehicle to approach the car, then this vehicle took off. The trooper then began the second part of the pursuit of this vehicle for the speeding infraction. However, at this point in time, while the trooper was then following this vehicle, that vehicle reached speeds up to 140 miles per hour on I-70. At some point in time, that vehicle then exited I-70 at what is the K-15 Abilene exit. And at that exit, there's a little hill, and the vehicle went down, and the trooper lost sight, and he went over the bridge, assuming that the vehicle went that direction, didn't see it, turned around to look, and then, determined that the vehicle had then, in fact, exited the highway at that location. So when this came up for civil forfeiture, the issue before the court was not so much of whether or not the vehicle was fleeing and eluding. That was pretty much agreed to by the parties, but whether or not the driver's actions of driving 140 miles per hour were reckless in and of themselves or per se.
Do we know how much time elapsed between the time the guy fled and the guy exited?
I'm sorry, he fled and what?
And then when he exited?
Your Honor, I can tell.
How many miles?
I cannot tell you exactly, but if you're familiar with that area of I-70, the initial stop was right by the Russell Stover chocolate factory, just west of Abilene, and then it's just, I don't know, 2 or 3 miles on down the road. It's not very far, and then you get to the Abilene exit, but I do not know specifically how far that is.
The district court made a number of factual findings.
Correct.
And from what I can tell, that they largely, match yours. Were there any findings of the district court you don't believe were supported by substantial competent evidence?
No, Your Honor, I think the district court made the findings that he could find. I think the district court unfortunately felt that his hands were tied in this case because of prior case law. I believe that if the district court had felt that he had the ability without the prior case law to make a finding that driving 140 miles per hour in a 75 mile per hour zone was per se reckless. But as the court referred to Perry versus Smith, which is a 1954 case in which it was stated that speed alone was insufficient to find reckless driving, and the trial court relied on that case in order to make a determination that his hands were tied. And that's what we're here for today, is that to explain or to have the court determine that the trial court's hands are not tied by that case. The court does have the ability to look at the totality of the circumstances of what was taking place during that pursuit or during this speeding incident. I don't want to call it a high-speed chase, well, that's kind of what it ended up being. but that he can take the totality of the circumstances and he's not required, there's not a bright line rule as he appeared to believe in Perry v. Smith.
And so in addition to the speeding,
Mhm.
setting the speeding aside, what other facts should we consider as part of the totality of the circumstances?
Okay. The other facts I believe is that obviously this was a knowingly and determination by this driver to travel at those speeds. Common sense for anyone who has been driving more than, a year realizes that the faster you go, the longer it takes for you to stop. Your reaction time is affected by that. You cannot stop a car on a dime. And when you're traveling at 140 miles per hour, if anything would have gotten in his way and gotten to the path of that vehicle, he would have had to have probably either slammed on his brakes, would not have been able to stop in time, and or caused himself harm, other individuals in the vicinity harm, and maybe even the trooper in this case harm. And that's where we're going with this, is that when you're acting reckless, you're putting every person's and property at risk. And there's no way, I mean, I understand that the argument is going to be, well, this was, early in the morning and there was barely any traffic. Do we want to go down that road where we're saying, but for the grace of God? So because nothing was there, then it's okay. But if by chance, a cow had wandered out on the highway, we'd be having a different conversation.
Does it make any difference that it's fleeing and eluding?
Well, I think it does, because obviously this individual has shown that he has no,
So there's more than just speeding involved.
well, there is. There's his lack of not stopping.
So another car chasing.
Yes, there's, a police car with lights and sirens.
Yeah,
He's
and
evading law
Surely the
enforcement.
court could have considered that.
Well, I think they did, in that the parties then, conceded that he was fleeing and eluding. But in order to get to the civil asset forfeiture, you have to flee and eluding as a felony. And in this case, the felony included the reckless driving portion of that. And so in order to show felony, fleeing, and elude for the civil forfeiture statute, we have to show that it was reckless driving.
So the error is that the court should have found the reckless portion.
I believe so, I believe that the court improperly relied on Perry v. Schmidt in this case. There are several other cases out there regarding fleeing and eluding that do not require, in order to have a felony, fleeing and elude, when you're talking about fleeing from law enforcement, to have other traffic infractions. It is reckless driving is what's required by the statute, not the reckless driving with 5 traffic infractions. That is also a part of that's a different statute. That's the criminal statute. That's not the civil asset forfeiture statute. It simply, as it stated, requires reckless driving pursuant to KSA 8-1566. Period. It doesn't have any additional requirements for additional traffic infractions. It's just reckless driving. And I believe the totality of the circumstances of what this driver was doing, where he exited the interstate, the time of day, the fact that he was putting the trooper at risk, potentially anybody else at risk who may have been on that highway, but for the grace of God, he was putting them at risk. And that is reckless, and it should be able to be found by the court to be reckless.
And the district court found that there were 2 gas stations at the bottom of the stop. At the bottom of the ramp, there was a stop sign there, and then a couple open gas stations.
I don't know if the district court found that specifically in their record. I did mention it in my brief that, at the bottom of that stop sign, there is a 24/7 gas station. There are 2 hotels at the bottom of that exit ramp.
But is that in the record?
Didn't the trooper testify to that?
Yes, I believe the trooper testified to that. And the trooper also testified that in his opinion, he didn't believe that vehicle could have stopped at that stop sign at the bottom. And as we've talked about, individuals that have been driving, the trooper should have been able to use his common sense and experience as an individual who has driven at excessive speeds in the course of his employment to understand the ability of a driver to stop a car that is traveling at that speeds. When the court determined Perry v. Smith back in 1954, we didn't have vehicles that traveled 140 miles per hour. Our speed limit wasn't 75 miles an hour.
Let me talk to you about that case, though.
Yes.
Because our duty as an intermediate court is to follow the Kansas Supreme Court law that it establishes. And in that case, there were factors other than speeding that the court said, yes, this is definitely wanton and it's enough. But in its syllabus, it says speeding alone is never enough.
It does, but that is also in a civil negligent case in which
Yes,
the
Jackie.
passenger, in this case, was suing the driver, for injuries he had just said sustained in that accident. And so I believe, and also in Perry, it required gross and wanton negligence, which again is not the mens rea necessary for reckless. It's totally different areas of the law. It's different mens rea that is required of the driver of the vehicle. In Perry, that was a civil, passenger who received injuries, who was filing suit for negligence. And that's why the court said speed alone was insufficient in that to show gross and wanton negligence. But in this case, for civil forfeiture, we are simply looking for reckless conduct, not
Do you have
negligent.
any cases that look at reckless context in the forfeiture context, but also looking at what is reckless?
The only case that I could find that I thought was close enough on point, which was mentioned in the trial brief by the attorney who tried this case, was the 2000, I believe it was 7 Ford Mustang case that he talked about in his trial brief. I'll get you that site.
If it's in the brief, we'll find it.
It is in the brief. And that was an incident, that case was where a Salina PD officer had pulled up to a stoplight and observed a vehicle next to him with a driver that he knew was suspended. So he turned on his equipment to effectuate the traffic stop. The driver then sped through the traffic light, the red light, almost hit another vehicle. The Salina PD officer disengaged his pursuit at that point in time because, worries about injuries to persons and so forth. Later found that individual at a gas station, not driving the vehicle, went ahead and arrested him. They did civil forfeiture on that, and the court found that he fled and eluded and therefore engaged in reckless driving by running the red light. There was no other traffic infractions noted by that court, and that was upheld as appropriate use of the civil forfeiture statutes. I have gone over my initial time. Are there any other questions? No? All right. Thank you, Your Honors.
Counsel for appellee, give us just a second to reset. You may begin.
May it please the court, counsel, gallery. Again, I'm Barry Clark, representing the claimant in this case. There's really only one issue in this case, and that is, did the judge err when he found that the state failed to prove by a preponderance that there was reckless driving in this case? And that's because for this to be forfeitable conduct, there has to be a felony committed. And to elevate a reckless driving charge, to elevate a fleeing and eluding charge to a felony, in this case, you got to prove there's also a reckless driving charge that's been committed during the course of that. I'm a little confused because when this case was tried, both sides agreed that speed alone was never enough to prove reckless driving. It's in the state's trial brief. The
That would be an
judge,
unusual concession. I mean, even if they conceded it, does that strike you as accurate? I mean, when you're looking at a state of mind of wantonness, recklessness, don't you always look at all the circumstances?
absolutely. And what we agreed on was that speed alone, in and of itself, with no other circumstances to aggravate that, is insufficient to prove reckless driving. That's what the Perry case.
Aren't there always other circumstances? I mean, where are you speeding? What are the conditions like? What are the weather conditions, the road conditions, the traffic? Aren't there always other circumstances
Of course,
that go into speeding?
we agree 100%. It would be a very different thing to speed 140 miles an hour through a school zone at 8 o'clock in the morning, as opposed to 140 miles an hour on a highway that's designed for high speed travel at night with no traffic around. Those are very different.
What about the fact, though, your client, so he sped approximately 114, then we have the traffic stop. He knows an officer is approaching before he takes off again to go the 140. I mean, isn't that an unusual circumstance? And he would know it's extremely likely this officer is going to follow him at a very high speed because he's already been stopped once?
Oh, I think it's reasonable for him to conclude that would happen, yes.
And
But
is there any reason we can't consider the potential harm to a law enforcement officer in that situation?
I suppose this court can. I'm just unaware of any circumstances in which that has been done before. I'm unaware of any precedent here in Kansas where that fact was considered with speed in and of itself to show recklessness. And, were that the case, I mean, wouldn't any fleeing and looting offense always prove a reckless driving charge as well? I mean, every fleeing and looting would be a
Is it
felony.
willful or wanton? Isn't the more accurate question willful or wanton conduct?
Well, wanton conduct,
It's in the disjunctive,
yeah,
willful or wanton.
sure, it's either on purpose, willful,
Mhm.
or it's done under circumstances where you recognize there is a probable result and
Or should
risk,
have recognized.
and you consciously disregard. You're completely indifferent to that probable outcome. That's what the case law suggests. I think we've all agreed that that's the standard in this case. The state, in its brief, suggests that the standard of review in this case is one of a de novo review, and we disagree with that. I mean, this is a factual determination by a trial judge who's clearly reviewed the totality of all circumstances. And that is a substantial competent evidence review.
Is there any disagreement by the state with any of the fact findings by the court? I didn't notice any.
Well, I didn't hear them disagree with that.
I think
mean, what
they're disagreeing with his legal conclusion.
well, they disagree with the legal conclusion insofar as they are encouraging this court to suggest that speed alone can constitute reckless driving. I mean, the judge correctly recites the law that factor by itself cannot constitute reckless. It's
You can't
Perry.
have a civil forfeiture in the absence of reckless driving.
You could, yes, you could, if you have a felony reckless driving. And for that to happen, you're going to have to show,
Even more.
well, yeah, I mean, you're going to have to prove that there are 5 or more moving violations committed during the course of that offense, which hasn't been shown in this case, or the record doesn't reflect it. So, kind of moving in reverse order here, what we hope the court will do today is, one, conclude that this issue about the propriety of following Perry is something that this court shouldn't undertake here today, insofar as this court's subordinate to the court that decided Perry. That aside, the judge who decided this case, there was a lot of focus in the trial transcript about this business of the driver of the car exiting the ramp and blowing through a stop sign at the bottom. I think I can concede that if it were proven that had occurred, where you went over a ramp into basically a blind spot, there's a stop sign at the bottom, and you just blow through that thing, that's reckless probably in and of itself with those kind of circumstances. But none of that's developed in the record in this case. What is
Inference.
Right.
Yeah.
It's implied.
Didn't see him, but
yes.
he had to get off the exit.
And which is why I spent a little time talking about the impropriety of stacking inference on inference. I mean, we can't infer that when he left the road, he wouldn't have seen the stop sign, or that he couldn't stop, and then infer from that he didn't stop, and then infer from that this is a circumstance that we can pile on top to show a reckless driving charge on top of the speeding. But-
The only record on that is the trooper's testimony, I think, that he didn't think somebody going that fast could have stopped at that stop sign.
Yeah, and you'll note I objected to that testimony. I thought it was speculative, And I thought there was a lack of foundation with respect to what seems to me to be expert testimony. The judge let it in, but then he very clearly discounted that testimony in his findings. He says that the KHP is not proven by a preponderance of the evidence that the Camaro failed to stop. That's a specific finding. That's completely inconsistent with the officer's testimony that, in his opinion, the car could not possibly have stopped and that he expected to see a collision at the bottom. And so clearly there's no corpus delicti of a collision. It didn't happen. And further, when the court, summarizes its opinion, it concludes that the vehicle fled and eluded. There's no dispute of that. There's no dispute that it at one point drove 140 miles an hour. But the court goes on to say that there's no other offenses that are proven in this case. One of those offenses would have been failing to stop at the bottom of the ramp. So I'm troubled. I'm troubled by the possibility of reweighing evidence in this case, looking at evidence that was never presented. And let me give you an example of that. In the state's brief, they say, well, look, back when Perry was decided, cars, that particular car had a top speed of 74 or whatever, that 85 miles an hour. But today's cars, this car can do 170 miles an hour. Well, there's no evidence of that in either the Perry case or in this case. And to suggest that cars in the 50s were tanks and are somehow safer than cars built today is just silly. We all know that there's a lot of design that goes into vehicles to make them collapse and absorb energy and that sort of thing. But I don't want to run down a rabbit hole here. None of that's developed in the evidence. There's nothing developed in the evidence about when someone approaches that exit ramp, what is their field of view going down the ramp? It's just simply not developed. And it's not my job to do that. It's the state's job to do that. So,
Counsel, I've got a question for you on your preservation argument.
sir.
Could you explain that to me, how the state has not preserved its challenge to Perry?
Well, it wasn't in the trial brief. It's not ever mentioned in any arguments verbally at the trial. In fact, my opponent, Mr. Wood, simply stood on his trial brief in closing arguments. So in my view, it's not preserved. I don't do appellate work regularly, Judge, but it seems to me that if you don't object to it at the trial level, you're out of luck unless it's clear evidence or clear constitutional error, that sort of thing.
I'd like to go back to Perry for a second. So one of the state's argument today is that it makes a difference that in Perry, you were looking at gross and wanton negligence within the context of a guest statute, okay? But then for our forfeiture purposes, we're looking at reckless driving under a criminal statute, 8-1566. And so does the context matter? Is it
The legal
the
context.
legal context matter?
I'm reticent to ever say that legal context doesn't matter in any circumstances. Sure, it matters. But my understanding of Perry was that, back in those days, if you're a guest in a car, mere negligence was inadequate for you to bring suit against the driver. You had to show something more than that, and in that case, it was wanton conduct. Well, in this case, to show reckless driving, they have to show either willful or wanton conduct, and wanton conduct, as we all know, is a conscious or a complete indifference to a known risk. So I think the criminal cases that have followed Perry have borrowed that language in an effort to be more clear in defining the wantonness in the reckless driving statute. And so, for example, Vaughn talks about it, and there's other cases as well. It's been cited repeatedly over the years for that proposition. I hope I've answered your question. I'm sorry, Judge, I've rambled here.
Well, what raises another question for me, though. I mean, if Perry is controlling as to what constitutes wantonness in this context we're here today, it doesn't speak to willfulness, does it?
I don't think so, Judge. I think it refers to wanton conduct. But again,
And that matters because under 81566, reckless driving is defined as any person who drives any vehicle in willful or wanton disregard for the safety of persons or property. So it seems to me, and that's kind of what I was getting at, that it may be a different legal standard because of that.
respectfully, Judge, I disagree. I mean, our reckless driving says willful or wanton. That's in the disjunctive. Either of those can be established to establish that offense, right? And I think that Perry talks about wanton conduct, which is one of those. I don't think Perry says you have to be willful and wanton. I mean, that would be inconsistent, right? That would be like saying something has to be done on purpose, but is also an accident of some sort. So I don't think they're inconsistent in my view, but that's just me.
We've probably got you off track. Do you have any closing remarks you'd like to make?
I'm just waiting for the counter to run down. So, no, I don't.
Any further questions? No? All right. Thank you.
Thank you. Appreciate you.
Appellant?
And just to follow up on the last questions you had to counsel, we have talked about the disjunctive of willful or wanton, and I would argue that the driver's actions in this case were definitely willful, as we've already established. He had pulled over for a few seconds.
And the statute is willful or wanton. It is written in the disjunctive.
That is correct, Your Honor.
Be one or the other or both.
Right. And my argument is that his conduct was definitely willful.
Didn't do it
He-
accidentally.
There's no accidentally pushing on the gas pedal to reach 140 miles per hour, Your Honor. I just don't see that happening. We've all driven down the highway and have had somebody, blow past us and we're going, oh my God, how fast is that guy going?
Well, can we distinguish Perry then because that was an analysis of wanton conduct?
I believe you can, and that's why I believe the trial court's reliance on Perry was misplaced. The trial court stated in their memorandum decision, the court therefore believes that under current Kansas law, the court cannot find felony, flee, and elude. Therefore, the court denies the request by the plaintiff. And in doing so, the court specifically stated and referred back to Perry that driving alone is insufficient to find willful or wanton disregard for the safety of property. But we're talking about recklessness, and we're talking it under the criminal statute as opposed to the civil statute. And that's why I think the court's reliance on Perry was misplaced. We're talking about reckless driving willfully under the guise of his mens rea. What was his mind? What was his guilty mind? And his guilty mind was to drive 140 miles an hour to get away from the officer who had pulled him over. Why he wanted to run from the officer, I don't know. But he did. And that's one of those things that officers out there on every day of the week are dealing with. And it's been in the news over and over and over again of individuals receiving tickets driving over 100 miles an hour throughout the state. Almost weekly we see that. And so we're asking the court to find that Perry is not controlling for reckless as it comes to reckless driving under the civil asset forfeiture statute. That the court can take the totality of the circumstances and does not have to say speed alone is, if that's all my officer can show me, then I can't find that civil asset forfeiture applies in this case, because we believe it does, just based on the standard reading of the reckless driving statute. Any further questions?
Questions? Thank you. Thank you both. And again, we understand the importance of giving you a timely decision, so we will take this under advisement and issue our opinion as possible. Thank you.